Today our topic is on should felons vote, and if so, how, and we'll be talking about that. Just a brief, before I introduce our speaker, I just want to tell you a little bit about the law in North Dakota. In North Dakota, if you're incarcerated as a felon, you cannot vote, but once you get out, you can. Even if you're on probation or parole, it doesn't matter what type of felon, what type of crime it is. On the spectrum in the United States, you can go to the far, let's use left, and I think it's Maine or New Hampshire or Vermont, one of those states where you commit any crime, you're in prison, you can still vote. If you kill 10 people, you can still vote. Or on the opposite end, there's a couple other states that roughly, I don't think exactly ban it forever, but are a lot more strict. Like you cannot vote if you're incarcerated, probation, parole. Some crimes you can never vote. And then there's some debate on whether how you get those rights reinstated, whether it's automatic or you have to go to application to the state or whatever. And today we're pleased to hear from Roger Clegg, who is the President and General Counsel of the Council of the Center of Equal Opportunity. He focuses on legal issues arising from civil rights laws, including the regulatory impact on business and the problems in higher education created by affirmative action. He's a former Deputy Assistant Attorney General in the Reagan and Bush administrations. He held the second highest positions in both the Civil Rights Division and the Environment and Natural Resources Division. He has held several other positions at the U.S. Justice Department, including Assistant to the Solicitor General, Associate Deputy Attorney General, and Acting Assistant Attorney General in the Office of Legal Policy. He is a graduate of Yale University, who beat the crap out of us in hockey, but I'm glad that I hope they go all the way after they've taken us out, and he currently resides in Fairfax, Virginia. Thank you for coming.
Well, thank you, Tim, for that very nice introduction, and thank you for the invitation to come here and speak. To show my nonpartisanship, I'm wearing a tie that has both Yale blue and North Dakota green on it. And I'm also hoping that the Yale goes all the way. I was glad to get the invitation, not just because I enjoy doing Federalist Society events, but Tim had suggested this topic, and I think this is a terrific topic. I really enjoy speaking about it, and I think it's very interesting because it involves some very fundamental issues. When you think about it, who should be voting? It doesn't get much more fundamental than that in a democracy. Just to give you sort of a roadmap of what my remarks are going to cover, I'm going to start out and talk about some federal legislation that is perennial. It keeps getting proposed, never passes, where Congress would preempt the different state laws that Tim talked about and have a one-size-fits-all approach that basically requires states to allow people to vote once they're no longer in prison. That is basically to require the kind of approach that North Dakota has now on a national basis. And I'm going to talk about why that law is unconstitutional, why the decision on who gets allowed to vote or whether felons should be disenfranchised is something that is constitutionally committed to the states. But then after that, I'm going to talk about the policy issue of whether it makes sense to disenfranchise felons or not, and the arguments in favor of disenfranchising felons, and then answering some of the arguments that are made on in favor of allowing felons to vote. And I'll try to allow plenty of time for your questions and comments, because as I say, it's an interesting issue, and it's I think a good one to talk about. For those of you who are interested in more information about this issue, I've written a paper for the Federalist Society. It's on the Federalist Society website, and that paper in turn is based on testimony that I gave to Congress a couple of years ago. And that testimony has at the end of it an appendix that lists a lot of other stuff that I've written, and in addition some sources from people besides me on this issue. So if you're interested in the issue, there's plenty to read. Okay, well, let me, as I say, begin by talking about this bill that has been proposed repeatedly over at least the last couple of decades, which would, as I said, preempt state laws with a federal requirement that in federal elections, at least, felons not be disenfranchised. The first thing that you need, if you're Congress and you want to pass a law, is you need to be able to point to some font of constitutional, something in the Constitution that gives you authority to pass such a statute. You know, the Supreme Court's made clear that that's the way the Constitution works. It's not just that Congress can do whatever it likes unless there's something in the Constitution that says they can't do it. It's that if the Constitution, if Congress wants to pass a law, it has to point to something in the Constitution that gives them that authority. So what could Congress point to in the Constitution that gives them the authority to pass a law in this area? Well, before answering that question, let me point out that the Constitution affirmatively gives to states the authority to determine who votes in elections, in federal elections, as well as state and local elections. You look at Article 1, Section 2, that it empowers the states to do that for House of Representatives elections, and then there are similar provisions other places in the Constitution for the Senate, and of course for the presidency. Now, of course, the states cannot exercise that authority in a way that violates some other constitutional prohibition. So, for instance, states would not be able to prohibit black people from voting in congressional elections because the 15th Amendment says that they can't do that. They wouldn't be able to bar women from voting because there's a constitutional amendment that says that they can't do that. But otherwise, it looks from the text of the Constitution like this is something that's left up to the states. Okay, so what can Congress point to as a basis for authority to act in this area? Well, the statute that I'm talking about, the Democracy Restoration Act, as it's called, points to Article 1, Section 4, which says that generally the states get to determine the time, place, and manner of elections, but that Congress can make exceptions in this area. So the idea is that this is something that affects the time, place, and manner of elections. That's the argument. The problem is that that's not really what time, place, and manner of election means. When you think about it, we're talking about who can vote in the election. That's really doesn't sound like it's sort of odd to say that that's a time, place, or manner requirement. That's something more fundamental than that. Time, place, or manner, particularly in context, sounds more like deciding where the polling places are going to be, what the polling hours are going to be, things like that, rather than the fundamental question of who can vote. And indeed, not only is that what the text of the Constitution suggests, but if you look at the Federalist Papers, both Hamilton in one of the papers and Madison in another paper spell that out. They say that, yeah, that's what that means. The only authority to the contrary is a lone opinion by Justice Black in a case called Oregon versus Mitchell that was written, I think, in 1971. And Justice Black had rather idiosyncratic views sometimes on interpreting the text of the Constitution, and this case was no exception. He thought that time, place, or manner could be read as giving Congress authority to decide who voted in federal elections. But not only did none of the other 8 justices join that opinion, but all 8 of them, as I recall, actually criticized that rationale. Even some of them who ended up voting the same way that he did rejected that rationale. Okay, so Article 1, Section 4 doesn't work. Well, what else might Congress point to? As we'll see later on in the discussion, a lot of the interest in this area is driven by the fact that there are racial disparities in who felons are. That is, a disproportionate number of felons in the United States in 2013 happen to be African Americans. So the effect of felon disenfranchisement laws disproportionately falls on African Americans. That's not disputed. So you might say, well, could Congress point to that as giving it authority under the 14th and 15th Amendments to pass this legislation? The answer is no, because the court has made quite clear that in order for there to be a violation of the 14th or 15th Amendment, you can't just have a disproportionate racial effect. You actually have to have something that is intentionally discriminatory. When you think about it, there are all kinds of things that have disproportionate racial effects. I mean, taxes, Medicare, healthcare, all kinds of things can be shown to have disproportionate effects on this or that racial or ethnic group. But that does not turn them into matters that, therefore Congress has authority to legislate because there's been some sort of violation. Again, the court has been quite clear that in order to have a violation of the 14th or 15th Amendment, there has to be discriminatory intent. And as I'll discuss in a few minutes, you can't make the case that these felon disenfranchisement laws were passed with any kind of discriminatory intent. The only way that Congress could have authority in this area would be to point not to the disproportionate racial impact that these laws have. It would have to actually say that, in its view, these laws were passed with the intent of disenfranchising African Americans or some other racial or ethnic group. And they can't make that case. The, I guess, most dramatic problem with the argument to the contrary, that is, that felon disenfranchisement laws have discriminatory intent in the back of them, and that Congress can act to correct that, is if you look at the 14th Amendment itself. And Section 2 of the 14th Amendment expressly contemplates felons not being allowed to vote. So the same people who wrote the 14th Amendment also said implicitly that they understood that states were going to disenfranchise felons. That makes it hard to make the argument that felon disenfranchisement laws are violating the 14th Amendment. The fact of the matter is that the practice of disenfranchising felons is something that has roots that go back to ancient Greece and ancient Rome. And the practice of disenfranchising felons was something that was in England and that came over to the colonies at that time. During the antebellum period, most states, north and south, did not allow felons, or excuse me, yes, that's right, did not allow felons to vote. And this was at a time when African Americans were not being allowed to vote anyhow. So it's very hard to say that this law was motivated by a desire to keep African Americans from voting because they weren't being allowed to vote anyway. After the Civil War, in the immediate aftermath of the Civil War, many of the states that were being basically run by the Republicans at that time and were very aggressively pro-African American voting, nonetheless passed laws that disenfranchised felons. And there was a very interesting article in the Yale Law Journal that came out about a year ago that talks about how, indeed, the people who passed the 14th Amendment were quite adamant about distinctions being drawn between felons and non-felons in who should be allowed to vote. It is true that in the post-Reconstruction era, once the Northern troops had left the South and the authority had been returned to the Southern states, there were 5 Southern states that passed disenfranchisement laws that were specifically tailored to keep African Americans from voting. They did that by specifying that some misdemeanor crimes in particular would disenfranchise people, and they figured that they were going to be using those crimes principally against African Americans, and that this would be a good way to keep African Americans from voting, was to say that people who were convicted of loitering, for instance, or something like that, would be disallowed from voting. Those laws are no longer on the books. They've been taken off the books. And if any of them were still on the books, they could be struck down directly without Congress having to pass a law like this. Indeed, the Supreme Court, in a unanimous decision in the 1980s called Hunter versus Underwood, struck down one of the remaining statutes like that. This one was one in Alabama. I think it's quite telling that no other lawsuits have been brought to challenge the existing felon disenfranchisement laws in the South or anywhere else. Frequently, the opponents of felon disenfranchisement laws will suggest that they have racist roots. But these are organizations that have plenty of money, that bring lawsuits all the time, and yet they never bother to bring a lawsuit challenging any of these as having such racist roots. And I think the reason is because they don't. The laws that are currently on the books have other perfectly legitimate motivations other than disenfranchising anybody because of skin color. So the landscape that we have today, as Tim said in the introduction, is a patchwork. We have some states, Vermont and Maine, which allow felons to vote even when they're in prison.